The Supreme Court chamber fell completely silent as Congresswoman Jasmine Crockett stood at the council's table, her posture straight, her expression calm yet commanding. Her voice remained steady, despite Justice Samuel Alito's third interruption in less than 5 minutes. For months, the conservative justice had courted controversy with increasingly pointed public comments, remarks that many legal scholars saw as breaches of judicial neutrality. And now, in this high-stakes voting rights hearing, his irritation with Crockett's precise, unflappable argumentation had become impossible to disguise. Congresswoman Crockett, that is not what the Constitution says. Justice Alito cut in sharply, his tone laced with impatience. The dismissal hung in the air. The gallery of attorneys, reporters, and clerks collectively held its breath as Crockett paused mid-sentence. Then, with deliberate calm, she turned her gaze directly toward the justice. For a heartbeat, neither moved. Slowly, she opened the leather portfolio resting untouched beside her notes. From it, she withdrew a single-aged document, its edges neatly tabbed. When she began to speak again, her tone carried not defiance, but precision, authority, and something deeper: conviction. What unfolded over the next 30 seconds would not only silence Justice Alito, it would reshape the national conversation about judicial impartiality and constitutional intent for years to come. Before this turning point, Jasmine Crockett had already earned a reputation as one of the most formidable constitutional minds in public life. Long before her election to Congress, she had built her career as a public defender and civil rights attorney, specializing in voting rights cases across the Deep South. She knew the mechanics of disenfranchisement not as an abstraction, but as a lived pattern. She had fought case by case, county by county. Though now a legislator, Crockett had never abandoned her license to practice law. When extraordinary constitutional issues arose, she occasionally stepped back into the courtroom, this case being one of those rare and defining moments. Justice Samuel Alito, by contrast, had recently become a lightning rod for criticism. At a Federalist Society dinner 3 weeks prior, he had declared, the framers expected states to secure elections, not Washington. That single line, widely seen as prejudging active litigation, set off a storm of op-eds and ethics complaints. Yet the Supreme Court, lacking a binding ethics code, had remained officially silent. Behind the scenes, Crockett had taken note. Her team had meticulously compiled archival research, letters, congressional records, and judicial opinions to trace the precise meaning of the Reconstruction amendments that Justice Alito so often invoked. The courtroom itself was a scene of electric tension. Legal correspondence filled every seat. Civil rights leaders lined the back row. The Chief Justice had granted extended argument time, recognizing that the outcome could redefine the boundaries between state sovereignty and constitutional protection. As Crockett stepped to the podium, a low murmur swept through the room. Many expected her to falter under Alito's famously aggressive questioning. Instead, her first words commanded the chamber's attention. Mr. Chief Justice, and may it please the court, the right to vote is not merely procedural. It is the foundation upon which every other constitutional right depends. Her cadence was steady, her tone respectful but unyielding. When 53,000 eligible voters in Jefferson County were turned away at the polls last November, it was not only a tragedy for them, it was a failure of our constitutional promise. The human stakes hung in the air before she pivoted seamlessly to her legal framework. The state argues that Article 1, Section 4 grants plenary authority to the legislature over election procedures. Yet that claim ignores both the 14th Amendment's equal protection guarantees and the profound transformation wrought by the Reconstruction Amendments themselves. Justice Alito leaned forward, interrupting sharply. The text of Article 1 is clear, Congresswoman. The Constitution gives primary authority to state legislatures. Is it not your quarrel with the Constitution itself? The interruption came barely 90 seconds into her argument, but Crockett didn't flinch. With respect, Justice Alito, my quarrel is not with the Constitution, but with incomplete readings of it. Article I cannot be understood apart from the amendments that followed. The Reconstruction Amendments fundamentally rebalanced authority to ensure that the right to vote was not subject to the same abuses that once denied it. She continued, grounding her points in precedent. Anderson v. Celebrezzi, Burdick v. Takushi, Shelby County v. Holder, weaving them into a coherent constitutional history. Justice Elena Kagan nodded subtly. Justice Brett Kavanaugh scribbled notes. Then came another interruption. These are inconveniences, counsel, not constitutional violations, Alito said tersely. Every regulation carries some burden. Unless you can show deliberate discrimination, these are matters for the states, not the federal courts. Crockett exhaled slowly, then redirected the exchange with clinical precision. With respect, Your Honor, this court's own doctrine says otherwise. In Anderson-Burdick, the court recognized that even absent discriminatory intent, any law that disproportionately burdens the fundamental right to vote demands justification grounded in legitimate state interests. And here, the Constitution, Alito interrupted a third time, does not guarantee convenience, Congresswoman. It allocates authority, and in this realm, that authority belongs to the states. The deliberate use of Congresswoman instead of counsel drew immediate attention from those in the gallery, a subtle but unmistakable breach of courtroom decorum, implying that her political role disqualified her from pure legal standing. Crockett paused. Then, without raising her voice, she looked him directly in the eye. The Constitution, Justice Alito, is not merely about allocating power. It is about restraining power to safeguard fundamental rights. And since you've invoked constitutional design, perhaps we should revisit what its framers actually said. Her words landed like a quiet challenge. She lifted the same leather portfolio, opened it deliberately, and withdrew a single document, aged and annotated. I've taken the liberty of reviewing the original congressional debates from 1869, when the 15th Amendment was drafted. You've suggested, both here and in public remarks, that the framers intended to give states near absolute authority over elections. But the record tells a different story. The courtroom grew still. Reporters stopped typing. Senator Oliver Morton, a principal architect of the amendment, declared, and I quote, "Its purpose is to place the power of protecting the right to vote in the hands of the federal government, where it rightfully belongs, rather than the legislatures of states that have proven unworthy of that trust." A hush fell. Justice Alito's pen froze mid-note. Representative James Garfield, later President Garfield, added that the Constitution must override all state regulations that burden the act of voting on conditions not inherent to voting itself. Crockett turned another page, and Senator William Stewart, who drafted the amendment's language, made it unmistakable. We are establishing not merely a prohibition against racial exclusion, but an affirmative guarantee that the right to vote shall be practically accessible to all citizens, regardless of station. She passed the documents to the clerk. The Chief Justice leaned forward. Justice Kagan exchanged a measured glance with Sotomayor. "These are not obscure quotations, Justice Alito," Crockett continued evenly. "They are the words of the framers of the Reconstruction Amendments, the very provisions you've invoked repeatedly today. Their meaning directly contradicts the narrow theory of state authority you've advanced in this courtroom and in your recent speeches." Alito's expression hardened. His eyes flicked briefly to the bench, as if seeking rescue, but no one moved. Crockett pressed on. The historical record leaves no ambiguity. The Reconstruction Congress intended not only to prevent explicit discrimination, but to ensure effective access to the franchise for all Americans. They understood that neutral laws could be weaponized to achieve the same suppression through more subtle means. That is why they placed federal responsibility where the states had failed. She paused briefly, allowing the silence to sink in before turning to the evidence at hand. In Jefferson County, 83% of voters who were turned away under this law were minorities, despite minorities comprising only 34% of the county's population. This statistical disparity alone would have outraged the framers of the 15th Amendment, who explicitly rejected the notion that states could use procedural mechanisms to accomplish what they could not do directly. Justice Barrett, who had been quietly observing the exchange, spoke for the first time. "Congresswoman Crockett, these historical sources are compelling. How would you of us apply them to the standard of review in this case?" "Justice Barrett, thank you for that question," Crockett responded. "These sources demonstrate that when reviewing voting regulations, this court should apply heightened scrutiny whenever a law results in significant disparities in ballot access, regardless of provable intent. The Reconstruction framers understood that the right to vote is preservative of all other rights and requires special protection from procedural encumbrances." Justice Alito attempted to redirect the conversation. "These are interesting historical footnotes, counsel, but they don't override the plain text of Article 1, which remains, with respect, Justice Alito," Crockett interjected calmly. "These are not footnotes. They are the authoritative explanations of constitutional meaning by those who wrote and ratified the amendments, and they directly address the relationship between Article 1 powers and the latter amendments designed specifically to constrain those powers." She turned to her final point. The Reconstruction Amendments fundamentally altered our constitutional structure, creating new limitations on state authority precisely in the context of voting rights. To read Article 1 as though these amendments don't exist is not textualism or originalism. It's selective constitutionalism. The phrase landed with quiet force in the chamber. Several law clerks seated in the back rows visibly reacted. And Justice Thomas, who rarely spoke during arguments, raised his eyebrows slightly. Chief Justice Roberts, recognizing the significance of the moment, extended Crockett's time by 5 minutes, a rare concession that signaled the impact her argument was having on the court. Crockett then methodically connected these historical insights to the specific evidence in the case, demonstrating how the state's voter ID law imposed precisely the kind of procedural burdens the Reconstruction Amendments were designed to prevent. In conclusion, she stated, looking directly at the full court, this case is not about convenience versus security as some have framed it. It's about whether we take seriously the constitutional commitment made in the Reconstruction Amendments, a commitment to ensure that the right to vote remains meaningful for all citizens regardless of their race, wealth, or status. She gathered her documents as her time expired, delivering a final line that left the courtroom in stunned silence. The framers of the 15th Amendment would recognize exactly what is happening in Jefferson County today. The question before this court is whether we have the constitutional courage to see it as clearly as they did. A collective intake of breath swept through the chamber. Justice Alito sat motionless, the historical evidence having undermined not just his questioning in this case, but positions he had been advocating publicly for years. Other justices exchanged glances that communicated the weight of the moment they had just witnessed. As Crockett returned to her seat, the usual murmurs that follow a powerful argument were absent. Instead, the Supreme Court chamber remained in reverent silence, absorbing the rare moment when constitutional history, legal argument, and moral clarity had aligned with such force. The aftermath of Congresswoman Crockett's historic Supreme Court argument extended far beyond the case itself, reshaping constitutional discourse and breathing new life into voting rights jurisprudence for years to come. Within days, legal publications were analyzing what many called the Crockett Brief, not just her oral argument, but the comprehensive written submission that expanded on the historical evidence she'd presented. Harvard Law Review dedicated a special issue to examining the Reconstruction era sources she had surfaced with noted originalist scholars acknowledging the significance of materials that had been overlooked in previous voting rights cases. What Crockett accomplished was remarkable, wrote Professor Aquila Marr of Yale Law School in The Atlantic. She used originalist methods to demonstrate that the original understanding of their Reconstruction Amendments was far more protective of voting rights than many modern jurists have acknowledged. It's a masterclass in how historical evidence can illuminate constitutional meaning. The impact on the court itself became evident 3 months later when the decision was announced. In a surprising 6-3 opinion, with Chief Justice Roberts writing for the majority and Justice Barrett concurring, the court struck down the contested voting restrictions while establishing a new, more protective standard for reviewing voting regulations. When voting regulations result in demonstrable disparities in access to the franchise, Roberts wrote, courts must apply heightened scrutiny to ensure that the state's interests are both compelling and cannot be achieved through less burdensome means. This standard flows directly from the original understanding of their Reconstruction Amendments, which fundamentally altered the constitutional balance between state discretion and federal protection of voting rights. Most notably, Justice Alito authored a concurrence rather than a dissent, a rare retreat from his previously rigid positions on state election authority. While maintaining that states retain significant discretion in election administration, he acknowledged that the historical record surrounding their Reconstruction Amendments, more fully illuminated in this case than in previous litigation, establishes meaningful constraints on that discretion when regulations significantly impact ballot access. Legal observers immediately recognized the seismic nature of this shift. Nina Totenberg of NPR called it the most significant recalibration of voting rights jurisprudence in decades, while legal scholar Richard Hast wrote that Crockett didn't just win a case. She changed the constitutional conversation around voting rights. For Crockett herself, the Supreme Court argument marked a defining moment in her already distinguished career. Though she continued serving in Congress, her constitutional expertise made her a sought-after voice in subsequent voting rights litigation nationwide. Law schools reported that applications from women of color increased significantly in the following academic year, with many citing Crockett's courtroom performance as inspiration. What Congresswoman Crockett demonstrated wasn't just legal brilliance. It was the power of bringing diverse perspectives to constitutional interpretation. explained Sherilyn Eiffel, former director of the NAACP Legal Defense Fund in a public forum at Georgetown. Law. Her lived experience as a black woman from the South combined with her legal training and political understanding allowed her to see connections in our constitutional history that others had missed. The broader impact on judicial ethics was equally significant. 2 months after the argument, the Supreme Court announced the adoption of its first-ever binding code of conduct, which included stricter guidelines for public appearances and stronger recusal standards. While no justice commented directly on the connection to Crockett's argument, the timing led many observers to conclude that her powerful demonstration of the link between public statements and judicial impartiality had catalyzed long-overdue reforms. In state legislatures across the country, lawmakers began re-examining voting procedures with new attention to disparate impacts. Several states proactively reformed voter ID requirements to ensure broader accessibility, while maintaining security, citing the Supreme Court's new standard as guidance. Conservative legal scholars, initially defensive about Crockett's approach, gradually came to recognize the intellectual consistency of her originalist methods. At a Federalist Society conference the following year, prominent originalist Randy Barnett acknowledged, "Crockett this reminded us that intellectual honesty requires following the historical evidence wherever it leads, even when it challenges our preferred outcomes." Her research into the original understanding of the Reconstruction Amendments deserves serious engagement from all constitutional scholars. The Crockett method, using rigorous historical research to illuminate the full context of constitutional provisions, became standard practice in major civil rights litigation. Law clinics at leading universities established projects dedicated to excavating similarly overlooked historical materials relevant to other constitutional questions. For ordinary Americans, especially in communities with histories of voter suppression, the impact was both practical and symbolic. Voter participation increased significantly in Jefferson County in the next election, with many first-time voters, specifically citing the Crockett case as their motivation for engaging with the democratic process. This wasn't about partisan advantage, Crockett explained in a PBS Frontline documentary marking the first anniversary of the decision. It was about ensuring that our Constitution fulfills its highest purpose, protecting the fundamental rights of all citizens, especially the right that preserves all others, the right to vote. When she returned to argue another case before the Supreme Court 2 years later, the atmosphere was markedly different. Justice Alito engaged respectfully with her arguments. Other justices referenced her previous historical research, and legal observers noted that the court's entire approach to voting rights questions had been fundamentally transformed. As constitutional law professors began teaching the case in their courses, they frequently emphasized that Crockett's most significant contribution wasn't just winning a specific case, but enlarging our understanding of what the Constitution means. By recovering the voices and intentions of the Reconstruction framers, she had helped restore a more complete vision of America's constitutional journey, one that recognized how each generation had expanded and deepened the promise of democracy. What began as a tense confrontation in the Supreme Court had evolved into something far more significant, a reminder that the Constitution is not frozen in 1787, but includes the transformative amendments that followed the Civil War amendments, specifically designed to ensure that democracy would become more inclusive rather than less. Crockett hadn't just won an argument. She had helped recover a constitutional vision that had been obscured for too long. In courtrooms and classrooms across America, her filing to the justices became a touchstone for discussions about constitutional interpretation. The framers of the 15th Amendment would recognize exactly what is happening today. The question is whether we have the constitutional courage to see it as clearly as they did. It was a challenge not just to 9 justices, but to a nation still working to fulfill its constitutional promises. A challenge that would continue to resonate long after that momentous day in